Hi, this is Steve Lombardi, and this is your Legal Minute. Today we're here to talk about fast food contamination, otherwise known as, hey, I got an object in my food that didn't belong there. I bit into it and I broke my tooth. Now, Mr. Lombardi, how can I get paid for this? How can I get the dental work taken care of? Well, for the most part, the answer is you can't. And here's the reasons why. First, you have a very high burden of proof in these cases. The reason being because there is so many other cases that came before you where the people who were pursuing those cases were just trying to get their teeth fixed and tried to defraud the company out of some money by putting an object in the food and then claiming that their broken tooth was caused by biting into it. I will say this, even if those cases weren't fraudulent, they looked fraudulent, and if they look fraudulent, the insurance company is going to say, you know what? If it looks like a duck, quacks like a duck, it's probably a duck. All right. The second problem we have with these cases are you need a lot of damages in order for us to pursue those cases. Otherwise, they're not economically feasible to pursue. You might ask why that is. Well, we need experts. We need experts on the damages. We need experts on the liability. And as such, in order to pursue that, we're going to have to spend thousands of dollars to get a few $1,000s. Well, if you get $10,000, you subtract a third for the attorney's fee, and then you spend $7,000 on experts. That leaves nothing for the client, which is you. Therefore, why would you want to pursue that case? The other thing you have to keep in mind is this. If this is McDonald's we're talking about, they got such deep pockets, they'll make our lives miserable just pursuing what amounts to a small claim action. Now, many of these cases could go in small claims if all your damages are $5,000. And I'll tell you this, if you want to take a shot at them in small claims, take a shot at them in small claims without an expert. Who knows, you may be able to argue your case, but you better successfully argue your case, but you better have witnesses who can back you up that you didn't put it in, that they were with you, that they saw the sandwich, they bought the sandwich there, you bit into it, and then there was the object. If it's an object that you take out that belongs in the kitchen and can be proven that it was in their kitchen, you got a much better chance of proving that case. Now, one more thing. Let me tell you the trick they pull. They all pull the same trick. All of these fast food managers are taught when a person like you comes to them with a foreign object that you say was in the sandwich, they all say the same thing. Give me the object and we'll send it in for testing. Then as soon as the lawyer gets involved, what they tell us is, well, they may have given us the object, we don't remember, the manager doesn't remember, but if they did, it's been lost. They're never going to test that object. They have no intention of testing it. Their intention is to destroy the evidence, the only evidence that you have that can prove what was in the sandwich and whether or not it came out of their kitchen. So, if you intend to pursue these cases in either district court or small claims, I would encourage you to keep the object, put it in an envelope or a plastic bag, and don't give it up. Keep it. Photograph it. Whatever you can to preserve it, preserve it. It's going to need to be tested later on, or at least in some way identified and then related to what is in the kitchen. Well, this is the end of this today. This is fast food contamination or an object in your food. This is Steve Lombardi, and this is your Legal Minute. If we can help you with any type of case, please give us a call by following the contact information that follows this video. Have a good day.